Good afternoon. This is another version of Can We Talk? Another segment, I should say. The follow-up to the first one where we discussed my petition for review that has been sent in to the Minnesota Supreme Court on February 25th, 2016. This is our analysis of the Court of Appeals decision, which I feel they erred in, and so did my attorneys. And this is Doug Olson from the Brainerd Area Coalition for Peace. He's going to be my guest today, and he'll be doing the reading, and I'll be talking about things as we go along.
I'm really happy to be here, Robin, and discussing the case with you. So if anyone out there is interested in looking up this case, they might be able to find it. Again, this was just recently decided, so it might not yet be online. But the case is State of Minnesota versus Robin, R-O-B-I-N, Lynn, L-Y-N-E, Hensel, H-E-N-S-E-L. State of Minnesota versus Robin Lynn Hensel. And it's a Minnesota Court of Appeals case, and they made their decision on January 25th, 2016. So very recent. And the appellate court case, thank you, Robin, for mentioning that. This might help in finding it. The appellate court case number is A15/0005. So A15/0005 from the Minnesota Court of Appeals. So it may not be up there yet, but it should be eventually. So hopefully they'll get it up soon. Now we're going to be, like Robin mentioned, discussing the case, so I'll be reading from it. And anytime, Robin, you'd like to jump in or something, we can discuss it. And we'll just go through with our analysis and where we believe the court erred in its decision.
And we should mention, this is the opinion of 3 female judges.
Mm-hmm.
The main judge was Michelle Larkin.
Yes. Yep, Judge Larkin. I
Does
think
it
that
say?
information
Oh,
is,
there we
yep,
go.
right here. Yep, considered and decided by presiding Judge Larkin, Judge Work, and Judge Bjorkman.
Okay?
All right. So here is the Court of Appeals case. Opinion, Judge Larkin. On appeal from her conviction of disorderly conduct for disturbing a city council meeting, appellant argues that 1. Minnesota statute section 609.72, subdivision 1, paragraph 2, violates the First Amendment. 2. The district court erred by denying her requested jury instructions. And 3. The evidence is insufficient to support her conviction. We affirm. Facts. Appellant Robin Lynn Hensel is a retired resident of the city of Little Falls. Hensel regularly attends Little Falls City Council meetings. Council meetings take place at the Little Falls City Hall in a room that has a raised dais where the council sits. Members of the public sit in chairs that are set out by the Public Works Director. On some occasions, tables and chairs have been set up in the area between the dais and public seating area to accommodate work sessions before the council meeting. Typically, the extra chairs are removed before the council meeting begins. The events underlying this appeal took place at the council's meetings on June 3rd and 7th, 2013. At the June 3rd meeting, the work session tables were set up between the public seating area and, I hope I'm pronouncing it, is it dais or dias?
Dais.
Dais, dais. Okay. Hensel brought signs to the meeting, which she placed besides the council dais and around her chair in the front row of the public seating area. She also wore a sign on her head. The mayor's husband was at the meeting, and he asked to sit at the work session tables. The council president allowed him and other members of the public to come forward and sit in front of Hensel at the work session tables. Then immediately, after the meeting was called to order, the mayor moved to close the meeting and reconvene at another time. And we went over some of what had happened at that meeting in our previous segment. The meeting was rescheduled for June 7th at 9:30 a.m. On June 7th, Hensel arrived at the meeting and seated herself in the front row of the public seating area. There were no tables and chairs between the dais, or dais? Dais?
Dais.
Dais. It's kind of a hard word to pronounce. Between the dais and the public seating area that morning. Before the meeting was called to order, Hensel twice moved her chair forward into the public area, forward into the area in between the public seating area and dais where council members were seated. Hensel asserted that she moved her seat forward because of what she believed to be unequal treatment based on events at the June 3rd City Council meeting. The first time Hensel moved her seat forward, the Public Works Director moved the chair back and told Hensel, We set the council chambers up and the chairs stay here, please. The second time, the police chief asked Hensel to move her chair back to the public seating area. She refused, and an exchange of comments ensued among Hensel, the police chief, the city attorney, and city council members. Hensel said that she would compromise and moved her chair partway back to the public seating area. When she refused to move her chair any further, the police chief removed her from the meeting. As a result of Hensel's conduct before the June 7th meeting, the council was unable to start the meeting at time. I mean, right there. I mean, you could see where the court's going to rule against Robin. I mean, just the way they're describing the facts. I mean, they really put you in the worst light possible because of your conduct, not because the city council decided to make an issue of this. They could have simply ignored what you were doing and, like Councilman Croder suggested, carry on the meeting, and we wouldn't be here discussing this today. But they made a big issue of it. They arrested you.
Well, they made a big hoopla and created disorderly
That's right.
conduct.
They disturbed their own
themselves.
meeting.
They
Yeah.
disturbed the meeting. It's
They
what-
disturbed their own meeting.
They confronted me in such a way so that they prevented their own meeting from beginning.
That's right. Had they...
And, you know, I forgot to
Sure, go
mention
ahead.
something in our earlier talk. So folks, if you want to hear the whole discussion about the petition for review to the Minnesota Supreme Court, that's in the first episode, and you'll be able to watch. And when is this going to be aired? What day again is it, Doug? Or Chris?
Tuesday and Thursday,
Tuesday and Thursday at 2
and 5:30.
2 and 5:30, 2 p.m. and 5:30. So be able to pick that up each week on channel 180. You asked about having lad there to observe and to take photos with my new camera.
That's right.
Originally, Teresa Scorset was dressed. She was wearing a hijab that day and a long skirt, and that was part of her free speech as well, is how she was dressed. She had intended, we had talked about moving forward together, and then she decided not to at the last minute. That's why I had to have Lad there to run the cameras and to take pictures, because I knew Teresa would be moving forward with me, and she
Right.
didn't.
Well, and it made
So-
sense, too, to have someone there to document what the city council was doing, because otherwise, many people just wouldn't simply believe you.
Right.
How could a city council behave so outrageously,
Right.
you know? And now you have the fact on camera, what exactly they did.
Mm-hmm.
So it was good, because I think you had an inkling. You didn't want to be arrested. You didn't want to disturb the meeting, and you didn't disturb the meeting. It was the city of Little Falls, the city council, that disturbed their own meeting by making an issue of what you did. But I think you knew going into it that there was a possibility that they'd make a big hoopla of this, and
Well,
something bad
I-
could happen, as far as them maybe arresting you or removing you, or, you know, just trampling all over your rights as they've
I
done.
never, in my wildest dreams, would have thought they would have ever.
You didn't think they were gonna arrest you? You
No,
didn't think that
no, I
was-
never dreamt that. In fact, I've often wondered, how come my attorney at the time, he's not a criminal attorney, he's a
Right.
First Amendment guy, but he never warned me about that.
So,
I had no idea.
what'd you think would happen at most, that they would just, you know?
Stop the meeting like they had on the third.
Okay, stop the meeting. So,
If
yeah.
they were, if that, logical. I mean,
Right,
who wouldn't have thought that? When I came in dressed in a
right.
different fashion, but obviously I was dressed in an outfit that I don't normally wear there.
Mm-hmm.
And they shut that meeting down, and my intent was not to shut the meeting down, but I figured that they would allow this meeting to happen regardless, because they had to pay the bills, and they had to authorize
And
their
I
signs.
think intent is key here. It is so key in criminal law. I mean, because there's actus rea, that's the bad act, and mens rea, bad mind. And you really have to have both most of the time for there to be a crime committed. You have to have intent to commit a crime. In this case, you would have had the intent to disturb the meeting, to break it up, and you had no such intent whatsoever. You
Well,
wanted to make a symbolic point.
As
that
a
yeah.
matter of fact, if I wanted to shut a meeting down, I would have been clear about it at the beginning, and I would have done something so that it would have shut down, like take my clothes off, or, you know. I
Well, you
mean,
could have sat in front of the city council doors or something, people couldn't even get into the meeting room. So, I mean, there are any number of things. Or like the Black Lives Matter activists, you could have stood right in front of the dais and just, told them, hey, we're shutting, you're going to listen to me.
Right.
And, I'm going to set the agenda today. That
well,
would have been, yeah.
And I would not have taken my clothes off, but the fact is, there have been protesters that have gotten
Yes.
in the street
Nude.
topless,
Yes, absolutely.
and some nude.
Nude,
I mean,
yes. I mean, there was a man not that long ago when the TSA groped people, going through the airlines. He actually went through one of their screeners nude, and he had, so he was butt naked, and he had the Fourth Amendment, written over with
Oh.
him with markers. And he was arrested and, charged with, among other things, with disorderly conduct, and the court ruled in his favor, saying that what he did was free speech. His intent was speech, so, and there are real-life examples of that.
Well, and to shut a meeting down, if I wanted to do that, all I had to do was have a great big sign out in my van.
Yeah.
Go out to my van, bring it in, and hold it up in front of the camera.
That's right.
That pretty much would have shut it down.
But that was never your intent.
No.
So,
My intent was to have some sort of a voice, some sort of a way to let the people know that my voice was still there, and they didn't have a public comment time at all. So, and here's the thing, if they had a public forum comment time at that meeting, you know what I'd have done? I would have stood up and said to them, you guys already erected an illegal sign on your own property on 2 sites in the city, the golf course and the zoo. And I would have asked them why they violated their own sign ordinance again.
Yeah.
That's what I would have said
Oh,
at my public forum
absolutely,
comment, but I
and-
couldn't.
many people may not know this if you're outside the Little Falls area, but Little Falls is one of the strictest sign ordinances in the state of Minnesota, extremely strict. But,
Well, not only that, it was
Yeah.
unconstitutional.
of course.
They've always had unconstitutional sign ordinances. The first one, or going back, the original sign ordinance that was in place in 2011, when all the issues came up with me, and I brought up the issue about the support the troops banner being illegal, that sign ordinance was unconstitutional. That's why they basically didn't do anything to enforce it for a full year. And then the new sign ordinance was also unconstitutional. The amendments were unconstitutional. And how do I know that? Because now they revised it again
Right.
because of the Gilbert v. Town, Town of Gilbert,
Town of Gilbert decision, yeah. Or
what's his name, the attorney?
Oh, boy, Robin, we'll have to look that one up, but I know exactly what you're referring
Reed,
to.
Reed v. Town of Gilbert.
That's right.
That's
Reed
the
versus
decision.
Town. That's a U.S. Supreme Court decision from just last year.
And
Just last year. Reed ver-
that's
Reed versus
not the
Town
end of the
Gilbert.
sign ordinance going forward. Somebody eventually is gonna challenge, because the decision that the judges made in that were key, and they said that pretty much even a marker sign, that's content-based.
Absolutely. And the U.S. Supreme Court, though it's quite conservative at times, especially in due process cases, has been pretty protective for the most part of what they consider core free speech. Very protective. Even the late Justice Scalia, was very protective of it. So, so once again, the case is Reed versus
Reed v. Town of Gilbert.
Town Gilbert, okay.
Right.
A very important case, and it could really change everything that's going on here in Little Falls as far as the sign ordinance. That is.
And everywhere.
Yes.
That was a pastor by the name of Reed, R-E-E-D, in a little town called Gilbert out in Arizona. And I also want to say something here. It's interesting that we have now a split Supreme Court, a federal Supreme Court.
That's right.
Because if my case gets heard, if the Minnesota Supreme Court takes on my case, and depending on how they decide, if they would rule against me, my attorney has said he would motion for the federal Supreme Court as well. He'd be willing to go that far with it. But now, of course, and I don't know how long it takes, I think it's about 6 to 9 months to get through the Supreme Court here, if I remember correctly.
Are you talking about the state Supreme Court?
Mhm,
Yeah.
State Supreme Court.
So it takes time. These cases can drag on for years, literally years. And then, of course, the thing with, I don't know how the state Supreme Court makes their decisions, but the U.S. Supreme Court, they need to give what they call writ of certiorari. You need to have 3 justices that agree to hear your case. But I think, in all honesty, if it went that far, I think they would hear your case, because it really does impact free speech. It really does. And again, like I mentioned before, the court is very protective of what they consider, core, speech, political speech.
Well,
so.
and something we didn't talk about in the last episode, my case is totally unique, because evidently nobody ever did what I did.
So
It's just
and
sitting in a
those-
chair
yeah.
in the wrong spot.
And those are the type of cases that courts, whether it's the state Supreme Court or the U.S. Supreme Court, are interested in hearing. They haven't ruled on it before. It's what they call de novo. This is new for them. This is where they can really set a precedent. So no, I really hope the state Supreme Court hears your case. I hope they rule in your favor. But if not, or for that matter, if the city of Little Falls, which is of course, represented by the state of Minnesota, if they want to keep fighting you, if it goes to the U.S. Supreme Court, that will be interesting to see what happens.
Well, Paul Reavers stated in the article in the Morrison County Record that the city of Little Falls now is out of it. From here on, going forward to the, he made a comment that they don't take very many cases,
Right.
so that he didn't think it was pretty unlikely that they would take my case.
I think they will, though. I mean, it's free speech. I mean,
But that was his comment, and he
Right.
said that the city of Little Falls, at this stage, if it does move on to the state Supreme Court, that it will not involve the city anymore.
okay, so it'd be what, the state of Minnesota then, or, because it has to
I
be.
don't know if it's
I-
legal Minnesota cities or how.
I think it would be the state
I
of
have no
Minnesota,
idea.
because this is a criminal case. The League of Minnesota Cities, is a public interest group, that, advocates certain things. They want model laws, which I quite frankly find to be very
Does it say on the front
conservative.
of the thing
Yes,
for
it
the
would be
petition
state of
for review?
Minnesota. Yep, state of Minnesota. So it'd be state of Minnesota. That's who you'd be, it's always been state of Minnesota,
Okay,
So, but yeah, you're saying that the city of Little Falls would really not have an active role in this?
Right.
Okay.
right.
So just to clarify, all right, now, if we could, go back here to our appellate court decision. All right, respondent state of Minnesota charged Hensel with disorderly conduct for disturbing a public meeting. Hensel pleaded not guilty and moved to dismiss the charge for lack of probable cause and on First Amendment grounds. The district court denied the motion. The district court reasoned that the statute was overbroad and that it reached speech and expressive conduct protected by the First Amendment, but that it could be narrowly construed to reach only conduct. The case was tried to a jury. Hensel requested a jury instruction regarding expressive conduct to advise the jury that if it found that Hensel's conduct consisted only of expressive conduct, it must find that the expressive conduct constituted fighting words to find her guilty. She also requested a jury instruction regarding the First Amendment that would have precluded the jury from finding her guilty if her disturbing conduct was inseparable from protected expression. The district court denied the request, reasoning that the First Amendment issues were legal issues for the court to decide. So right there, it almost guaranteed your conviction. With the way the Minnesota statute is set up and how broad it is, it's pretty easy to get a disorderly conduct conviction if that's what people want to do. Had the court granted your jury instructions, then I think the jury would have acquitted you. I don't see how they could have if they
There's
followed
a
that.
state Supreme Court case here involving, I think his real name was George Watuki. His nickname is Butch Watuki, and I want to say it's a 1970 Minnesota Supreme Court decision on disorderly conduct. And what happened in that case, he was at the West Side Bar. There was a female bartender, and he brought in a stray cat. And I didn't know him at all. I think he maybe went to prison for something, I don't know, but not that charge. But he brought this stray cat in, and he ordered the bartender, he asked her to give the cat a shot of whipping cream, a shot of cream. And then he ordered something for himself too, and he also asked her to give him, to give the cat an order of jerky, beef jerky. And he put the cat on the bar. And so she proceeded to do that. And then some time passed, and you can look this case up for yourself, so don't quote me word for word. I'm just giving you a short analysis here. After some time, the bartender wanted the cat removed, and so she ordered him to take the cat outside. And he refused, and then a big argument ensued. And because she was a female bartender and she was the only staff on duty at the time, and because of some words that he had used, I don't think he threatened her. What he said, he called her some kind of obscenity. I forget what it was, but he called her a name, and the court ruled that he committed disorderly conduct because she was sort of trapped. She couldn't call out to get help or anything.
Right.
So,
And that is completely distinguishable from your case, totally. I mean, the city council wasn't trapped.
Right.
You didn't use any obscene words. I
Right.
mean, it's just totally different. I mean, totally different facts here. Now, the jury returned a guilty verdict, and the district court denied Hensel's request for a judgment of acquittal. The district court sentenced Hensel to 15 days of state jail time and placed her on unsupervised probation to the court for 1 year. Hensel appeals. Issues. 1. Did the district court err by denying Hensel's motion to dismiss on First Amendment grounds? 2. Did the district court abuse its discretion by denying Hensel's requested jury instructions? 3. Is the evidence sufficient to support the conviction. Analysis. Hensel was convicted under Minnesota statute section 609.72, subdivision 1, paragraph 2, which provides that whoever does any of the following in a public or private place, including on a school bus, knowing or having reasonable grounds to know that it will or will tend to alarm, anger, or disturb others, or provoke an assault or breach of the peace, is guilty of disorderly conduct, which is a misdemeanor.
And it's on the back of that page.
Yep. And 2, this is the paragraph that, we keep going back to, disturbs an assembly or meeting, not unlawful in its character. This is the key.
So it's really broad.
It is very broad. Disturbs an assembly.
Any meeting, it doesn't say
Yeah.
government meeting
No,
even.
it could be any meeting.
Church meeting,
Yes.
Tea Party meeting,
A BACP brand or
voter
peace
meeting,
Yes.
caucus.
Any number of meetings, yeah. Could be,
Right here, we're
private
a meeting.
get-together. Yes, we're a meeting.
We're
so-
two, we get 3 of us, because Chris is here filming.
That's right.
So if he started to interrupt us, guess what? He could be arrested for disorderly conduct.
Theoretically, yeah, under the statute, it's quite possible. I mean, yeah,
It's
I
true.
mean, it's true. I mean, if you read this thing, it is true. I mean, and this is where, and we'll get more to this, where the Court of Appeals made a big mistake. They could have really narrowed this thing down, but they didn't. Hensel argues that the statute is unconstitutional, that the district court erred in instructing the jury, and that the evidence was insufficient to support her conviction. We address each argument in turn. 1. Hensel first asserts a First Amendment facial challenge to Minnesota statute section 609.72, subdivision 1, 2, arguing that it is both vague and overly broad. To be a constitutional exercise of the police power of the state, a statute that punishes speech must be neither overly broad nor unduly vague. Henry Welfare of SLG, and that's a Minnesota Supreme Court decision from 1978. This court reviews the constitutionality of a statute de novo, meaning that it starts from scratch, it's new. State versus Crowley, Minnesota Supreme Court 2012. In a case involving a First Amendment challenge, whether First Amendment concerns are actually implicated is a threshold inquiry. State versus Stockwell, Minnesota Court of Appeals 2009, review denied by the Minnesota Supreme Court later that year. The party asserting First Amendment protection bears the burden in this regard. And this is citing that same case, citing Clark versus Community for Creative Nonviolence, a U.S. Supreme Court decision from 1984. The state asserts that Hensel has not met this burden because no spoken word or expressive conduct comes under the control of Minnesota statute section 609.72, subdivision 1, paragraph 2's reach. We disagree. The language of the statute is clearly broad enough to encompass both speech and expressive conduct. So right here, the court did disagree with the state of Minnesota. See Minnesota statute section 609.72, subdivision 1, paragraph 2, penalizing all conduct that knowingly disturbs a meeting. It does not distinguish between speech or non-speech conduct. Hensel has met the threshold burden in demonstrating that First Amendment concerns are implicated in this case. So they do acknowledge that, there is a First Amendment issue here. To succeed on our facial First Amendment challenge, Hensel must establish that no set of circumstances exists under which the statute would be valid, that the statute lacks any plainly legitimate sweep, or that a substantial number of its applications are unconstitutional, judged in relation to the statute's plainly legislative sweep. Rue, and that's looks like a Minnesota Supreme Court decision. We do not evaluate the facial constitutionality of a statute in a vacuum. In other words, something has to happen. Courts don't look at things that are just theoretical. There actually has to be a case for them to, and facts for them to consider right here. Rather, the task in evaluating a facial challenge is to determine whether a statute is unconstitutional in a substantial manner, or all of its applications. As the case may be, under the applicable constitutional standard governing challenges of the type brought by the party alleging the unconstitutionality of the statute. So in other words, basically, the statute either has to be totally unconstitutional, or at the very least, a big part of it has to be unconstitutional, the way it's applied. In Minnesota statute section 609.72, subdivision 1, 2 is not unconstitutionally vague in the court's opinion. As generally stated, the void for vagueness doctrine requires that a penal statute define the criminal offense with sufficient definitiveness that ordinary people can understand what conduct is prohibited and in a manner that does not encourage arbitrary and discriminatory enforcement. State versus Newstrom, Minnesota Supreme Court case from 1985, quoting Calander versus Lawson, a U.S. Supreme Court case from 1983. The vagueness doctrine is based on fairness and is not designed to convert into a constitutional dilemma the practical difficulties in drawing criminal statutes, both general enough to take into account a variety of human conduct and sufficiently specific to provide fair warning that certain kinds of conduct are prohibited. State versus Encart, Minnesota Court of Appeals, 2004, quoting Colton versus Kentucky, U.S. Supreme Court decision from 1972. A higher standard of certainty of meaning is required for statutes that impose criminal penalties, of course, because you could lose your freedom, so they better be well defined. Newstrom, State Supreme Court decision. But even a criminal statute need not be drafted with absolute certainty or mathematical precision. Dunham, State Supreme Court decision, stating the principle in a case involving a quasi-criminal statute and noting that for purposes of a vagueness analysis, a quasi-criminal statute is tantamount to a criminal one. And see also Enard, another State Supreme Court case. The vagueness doctrine does not preclude the use of broad, flexible standards that require persons subject to a statute to exercise judgment. Instead, uncertainty invalidates a statute only when those subject to it cannot determine with a reasonable certainty whether a particular act is forbidden or permitted. Einhard, State Supreme Court case, citing State versus Kolovar, State Supreme Court case from 1963. Applying these principles here, we conclude that Minnesota statute, section 609.72, subdivision 1, paragraph 2, is not void for vagueness. The statute must be construed in context and in light of its intent. See State versus Hip, Minnesota Supreme Court decision from 1973, rejecting vagueness challenge to public assembly statute after examining its content and intent. Although not defined by the statute, the term disturb is commonly understood to mean to break up or destroy the tranquility, order, or settled state of. American Heritage Dictionary. See also Black's Law Dictionary. Defining disturbance of a public meeting as the unlawful interference with proceedings of a public assembly. Thus viewed in context, a statute can be understood by persons of common intelligence as prohibiting conduct that could be expected to interfere with the ability to conduct a meeting. The fact that Minnesota statute section 609.7.72, subdivision 1, paragraph 2, does not specifically itemize what conduct disturbs a meeting does not compel the conclusion that it is vague. C. Dunham, from the previous State Supreme Court decision, explaining that a criminal statute need not be drafted with absolute certainty or mathematical precision. Rather, as our Supreme Court recognized in Hip, more specific statutory language may be infeasible. Because of the nature of the offense, which contemplates a form of conduct repugnant to good order and not a specific act, the language of the statute must, as a practical necessity, be general to cover the countless variations of conduct which can disturb or threaten the public peace. Reasonable enough. I mean, you can't list every single thing that could do it. And this is from the Hip Supreme Court case. See also State versus Kroski, Minnesota Supreme Court, 1988, holding that a statute prohibiting interference with peace officer performing duties was not vague, and noting that given the wider variety of circumstances in which the type of conduct the statute legitimately seeks to prescribe can occur, it seems unlikely that a substantially more precise standard could be formulated which would not risk nullification in practice because of easy evasion. In other words, sometimes they don't want the legislatures to write up a certain list of conduct that are prohibited because a person could say in their defense, well, what I did wasn't prohibited by the statute. In other words, they want to give them a little more leeway to prohibit even more conduct. Minnesota's approach is consistent with that of other states. See State versus McNair, a Nebraska Supreme Court decision from 1965. What constitutes a disturbance of a lawful assembly is not susceptible to a specific definition, but must depend to some extent upon the nature and character of the particular assemblage. However, while it may be difficult to specifically define beforehand, there is no problem in determining what constitutes a disturbance in a given case. People versus Malone, New York Appeals Court from 1913. Noting that although what shall constitute a disturbance cannot easily be brought within a definition applicable to all cases, there is commonly no great difficulty in ascertaining what is a willful disturbance in a given case. Notably, laws prohibiting the disturbance of public meetings are neither unique to Minnesota nor of recent vintage, and such laws are generally construed to prescribe only those disruptive physical actions and verbal utterances that are in violation of the normal customs and rules of governance, implicit or explicit, of the meeting. And this is from American Jurist Volume Disturbing Meetings, Volume 1, 2008. See also State versus Linares, a Connecticut Supreme Court decision from 1995. Construing statutory language prescribing intentional disturbance, disruption, or interference with General Assembly proceedings as limited to actual impediments to the legislative process based on the objective qualities of the conduct. We conclude that Minnesota Statute Section 609.72, Subdivision 1, Paragraph 2, is subject to a similar reasonable understanding and thus is not unconstitutionally vague. What do you think of that, Robin? I mean, it's a lot of verbiage, but they're basically saying the statute is not vague.
Well, I think that the statute itself has a problem with the second prong, not agreeing with the third prong, not being consistent there. And I can see from my own two criminal attorneys clearly laying out that this could, if this disorderly conduct thing isn't modified by the Supreme Court, you and I'd be talking on the street and somebody would come up and interrupt us. We could go right down to the police department and say, hey, this person is on camera. I had my camera with,
Sure.
so I recorded this. Joe Schmo here interrupted our conversation. Maybe he didn't even raise his voice. Maybe he just said something that we just absolutely didn't like.
Right.
And he interrupted our meeting. Guess what? Technically, he just committed disorderly
Or the
conduct.
because two or more people constitute
That's a
meeting.
problem.
Yes, that is a problem.
And I can't imagine that our Supreme Court in Minnesota would be that, I don't want to know what the word I want to use here.
You'd like to think that they would be able to use some common sense and say that that is not disorderly conduct.
Well, if our, and I have to be careful what I say, I'm going to rely on the intelligence level of our Supreme Court to figure out that we got a problem here in Minnesota. This doesn't just involve my case, although my case is what's bringing this to the forefront. But they have a big problem with the disorderly conduct.
And I hope your
charge here in
attorney, and I'm
Minnesota.
sure he will, he's a very talented attorney, Mr. Rich, is it?
Rich, pronounced Rich,
Rich.
yeah.
I'm hoping that he mentions some of this, in his arguments before the court, and he should also, if he is not already planning to do so, use the examples that you've mentioned earlier about Black Lives Matter activists disrupting meetings in the Twin Cities and not being arrested, doing conduct that was really disruptive, shutting the meetings down, and they made it quite clear that that was their intent, to shut the meetings down, whereas you had no intent to shut the meetings down. That was never your intent. You just wanted to make a symbolic statement.
Mm-hmm.
The city council could have still carried on their meeting, and yet they arrested you. There's
Well,
a real
I
problem
had
with
no
that.
voice. There was no public forum comment at that meeting. And the meeting before that, they had taken the public forum comments off the air. So I had no ability to get my ideas or whatever I wanted to say out to the public. And frankly, I couldn't be much more committed than I have been in the last 5 years. I've attended not only all the city council meetings, I've attended most of, at least in the first 4 years, the economic development meetings, the park recreation and tree meetings, I attended some of the housing meetings in town, some of the airport meetings. I attended almost every historic planning commission meeting. I went to most of the environmental and energy meetings. Economic development, I went to almost all of those. I ran for city council in 2012. I ran for mayor in 2014. I intend to run for Ward 1 this coming fall. And I intend to challenge whoever's going to run, however many number of candidates there are, in 2018, because we need a leadership, and I'm not a politician. But I can clearly see that we have massive problems in this area because we don't have a council that even knows how to or decides to vote constitutionally. They continue to violate my rights on a regular basis, and we'll see what happens with this decision of
That's right.
the seasonal display. I think that was an unconstitutional decision.
Given Reed versus City of Gilbert.
Right. We'll see what happens with the decision that they made to deny me to have a permanent display in a city park, since they have allowed the veterans groups, the VFW here in town and the American Legion, and the city of Little Falls, all has money, all decided together, although the council's the one that passed, that said they could have it, and yes, there's a Minnesota statute that says they can have the veterans parks. But you have to remember something, folks. Every single veterans park in every state, but let's take Minnesota just in itself, has signs. Words, letters, they're signs. All the inscriptions on the monument markers, there's lettering on the flags, there's lettering on each little inscription over here at the one by the post office, our local veterans park. All those little plaques that have the names and the dates of the deaths of the people that served, those are all signs, folks. So I can't imagine that the Reed v. Town of Gilbert doesn't apply with
I think it does. It
the two
definitely does,
cases
because
that were decided here
does.
by and if it's decided by somebody that has a lot more knowledge than our city council does, that they violated, that they shouldn't have voted against denying me and everybody else to have a seasonal display after December 30th of this year, and that they had no right to deny my request for a permanent display, guess what? That would mean that every single council member voted unconstitutionally again, and that matters, folks.
it absolutely does matter. And you're absolutely right, too, getting back to the Veterans Park issue, sometimes there can be a bit of a, maybe not explicit, but an implicit message, is that, some of these parks, I mean, we want to respect our veterans, we want to honor them, but sometimes some of them, however unintentionally, may also be honoring the wars, through their messages, and you don't.
Well, of course it is,
Yeah.
because the inscription on the plaque over here, on the big marker off to the right-hand side, there's a center one, there's a left-hand sided one, and there's one on the right, and it says Operation Iraqi Freedom.
Right, which is the official name, but.
And we were misled and lied
Right,
into that war.
absolutely we were. That was a criminal war, pure and simple. Criminal under Kellogg-Briand, which bans all aggressive warfare. There are no exceptions in Kellogg-Briand. The only just war is a war of pure self-defense when another nation is under attack by another nation. That's it. There are no exceptions.
And now, so we know that that plaque is honoring a war that was illicit, illegal, flat out. First of all, we had no business invading a sovereign nation, even if they had
Absolutely.
had reason to do it.
Right.
We-
I mean, how hypocritical the United States, let's say for the sake of argument, and he did not, but Saddam Hussein had weapons of mass destruction in Iraq. My thing is, how hypocritical the United States to attack Iraq when the United States has weapons of mass destruction, thousands of nuclear
Right.
warheads, as well as chemical and biological weapons, or the ability to produce them pretty easily. And, just totally hypocritical. The fact of the matter is, Iraq never attacked the United States. The United States was the aggressor in that war. Pure
Well,
simple.
and Congress never authorized that war
No, it was
until
never-
after the fact.
Right. There was no declaration of war. In fact,
Right.
there has not been an official declaration of war from the U.S. Congress since June 5th, 1942.
And that violates our Constitution because we have aggressed on nations in that time.
That's right. So, yeah, I mean, it is outrageous. And so I think, really, there should be an opportunity for anti-war activists, including anti-war veterans, such as our friends in the Veterans for Peace, if they wanted to put up a plaque or a marker at a veterans park, saying that these wars were wrong and that we don't want more young men and women being killed. And that, yes, we want to remember the young people who died, because it's usually young people who die in these wars. And we want to know why they died. What was the reason behind this? Instead of just being told, well, they died defending their country. Well, actually, no.
Well, and isn't it just as important to commemorate in some park, somewhere, the peacemakers?
Yes, I
and the
agree.
people who worked. Carnegie, for instance, gave all this money to our library and libraries all over the world, and the Carnegie Endowment Fund and all that. That's peace education.
Yes.
Where is the commemoration in town for that?
Absolutely.
I
Or
asked
Charles Lindbergh. I
Right.
mean, he's a controversial case, we know that, but he too, advocated for peace. I think he had some views on Nazi Germany that were being very generous, highly questionable, but still, he was at one point in his life, his father especially.
His father
was-
opposed for
oh,
World War
His
I.
father was really a good peace activist, opposed World War I, Charles Lindbergh Sr.
And free speech is all about a balance, allowing everyone to have their voice, even if it's a controversial issue.
That's right.
Even if it's something that people just absolutely abhor.
Oh, yeah. You know who I think would be fitting to honor in a Veterans Park would be General Smedley Butler.
Yes.
Who wrote War is a Racket.
Yes.
Two-time Medal of Honor winner. Fought in every major war the United States had between the Spanish-American War and World War I. Fought in the Philippine Rebellion, fought in Central America and China. And he came to the conclusion that war is a racket. And he wrote a great book in 1935, which all these years later, you're talking over 80 years later, is still very applicable. He could have wrote it today.
Right?
I would love to see a monument, honoring him and, his contribution to the peace cause. I really would, so.
So my request to have a seasonal display, an additional one, because I only got 1 year, but the Lindbergh Lions got 2 years' worth, so that's unfair right there. They got twice the speech that I did.
Yeah.
And they've also now denied everybody's
Right.
free
So
speech
they're
in a
trampling-
seasonal
yeah,
display.
They're trampling on everyone just to get to you.
Everybody,
Yeah.
not just mine. And they denied a permanent display. What right do they have to say that we should honor and venerate the soldiers some more and the wars and the atrocities that go with it, but we can't honor peace?
That's right.
That's not acceptable, folks. That's atrocious in America.
Yeah, and city-owned property. This is
On
the key.
city-owned property.
I mean, if the, say, American Legion, Veterans of Foreign Wars, if they own that park, they
Right,
maintained it, they
right,
paid for it, it was
right.
theirs. They would have every right
Yeah,
to.
but they don't.
They don't. If it's city property, that is key.
I don't think that there's any city in Minnesota that I've discovered yet that the Veterans Memorial is not on city-owned property.
Right.
It is in Long Prairie, it is in Randall, it is in Pierce, it's all over the place.
We have one in Brainerd too,
And,
so.
and that's a mistake. They should have it on their own personal property.
Well, they can have it on city property. I have no objection to doing that, but they cannot, again, citing Reed
Well-
versus Gilbert, say that, we can have, the VFW and American Legion, which tend to be very pro-war organizations, they can put up their monuments, but Veterans for Peace, another veterans
Right,
group,
right.
they can't put up their anti-war monuments.
Right.
That's discriminatory.
Right.
That is discriminatory.
Yeah.
So, and
Right.
that is a key point right there.
I think we're down to
All right.
less than a half hour here.
Yeah,
so-
let's continue with this decision here. Okay, this is the second part of the court's analysis. Minnesota statute section 609.72 subdivision 1 paragraph 2 is not unconstitutionally overbroad. As we noted above, determining facial validity requires this court to evaluate whether, assuming the application of appropriate constitutional scrutiny, a substantial number of hypothetical applications of the statute would violate the First Amendment. Rue, Minnesota Supreme Court case. There are undoubtedly applications of Minnesota statute section 609.72 subdivision 1 paragraph 2 that will implicate both core speech and expressive conduct. Core speech being, the expression of ideas. The statute prescribes disturbance of meetings, which certainly could take the form of speaking out of turn, heckling, shouting, chanting, and other forms of oral protest. Disturbances could also take the form of expressive conduct, like Hensel's refusal to move her chair in this case. The fact that speech and expressive conduct are implicated, however, does not end the inquiry. It merely prompts the next question, which is whether restrictions on these forms of expression could withstand the applicable constitutional scrutiny, again citing Rue. In this case, we conclude that it is appropriate to apply the test for time, place, or manner restrictions articulated by the United States Supreme Court in Clark, a very famous case from 1969. The court has made clear that the First Amendment does not guarantee the right to communicate one's views at all times and places or in any manner that may be desired. Heffron versus International Society for Krishna Consciousness, Incorporated, U.S. Supreme Court case from 1981. Time, place, or manner restrictions are valid provided that they are justified without reference to the content of the regulated speech, that they are narrowly tailored to serve a significant governmental interest, and that they leave open ample alternative channels for communication of the information. And again, they're saying the Clark case from the U.S. Supreme Court. Hensel does not dispute that Minnesota statute section 609.72 subdivision 1 paragraph 2 is content neutral. Accordingly, we turn to evaluating whether the statute is narrowly tailored to serve a significant government interest and whether it leaves open ample alternative channels for communication of information. We have no trouble identifying the governmental interest protected by Minnesota Statute Section 609.72, Subdivision 1, Paragraph 2. The statute protects the ability of governmental officials to do the work of governing. C. Linares, and that was a Connecticut Supreme Court decision, recognizing government interest and prohibiting interference with state general assembly. Smith Coronia versus United States, and D.C. Court decision from 1998, recognizing government interest in not allowing persons to delay, impede, or otherwise disrupt the orderly process of the legislature, which represents all Americans, and they're referring to Congress there. State versus Cephas, an Ohio Court of Appeals decision from 2005, identifying significant governmental interest as ability of government officials to conduct official business in an orderly manner without interference or disruption. The statute also protects the rights of all citizens to meet and participate in government. See Enrique, a California Supreme Court decision from 1970. The constitutional guarantees of the free exercise of religious opinion and of the rights of the people peaceably to assemble and petition for redress of grievances would be worth little if outsiders could disrupt and prevent such a meeting in disregard of the customs and rules applicable to it. Moorhead versus State, Texas Criminal Court of Appeals, 1991. We have no doubt that the state has a legitimate, even compelling interest in ensuring that some individuals' unruly assertion of their rights of free expression does not imperil other citizens' First Amendment freedoms. Having identified the significant governmental interest, we next consider whether Minnesota Statute Section 609.72, Subdivision 1, Paragraph 2 is narrowly tailored to serve that interest and whether it leaves open ample other channels of communication. We begin by observing that the statute applies in a very limited context. It only prescribes the disturbance of lawful assemblies or meetings. Minnesota Statute Section 609.72, Subdivision 1, Paragraph 2. Moreover, as we observe above, this prescription is reasonably understood to reach only conduct, including speech, that would be expected to interfere with the ability to conduct a meeting. Furthermore, the statute penalizes only conduct that is intended to cause a disturbance. See Minnesota Statute Section 609.02, Subdivision 9, Paragraph 1, 2012. When criminal intent is an element of a crime in this chapter, such intent is indicated by some forms of the verbs know or believe. 609.72, Subdivision 1, requiring that the actor know or have reasonable grounds to know that her conduct will or will tend to alarm, anger, or disturb others or provoke an assault or breach of the peace. Based on all the foregoing, we conclude that Minnesota Statute Section 609.72, Subdivision 1, Paragraph 2 is narrowly tailored to serve significant government interests. See Krotsky, a Minnesota Supreme Court case, concluding that statute prohibiting interference with peace officer performing duties was not overly broad because the statutory prohibition was limited to conduct obstructing or interfering with police officer performing duties and required that actor intend to obstruct or interfere. See also Smith versus Corona, concluding that statute precluding intentional disturbance of congressional sessions was narrowly tailored because it restricted the prohibited conduct to loud speech and other acts both of a nature to and specifically intended to disrupt the business of Congress, and that was that D.C. Court's decision. We also conclude that the statute leaves open ample other channels of communication. Citizens like Hensel are free to communicate their dissatisfaction with their government in a variety of ways, as long as those communications do not disturb lawful meetings. We are cognizant that some courts, and I think this is key right here, because they are recognizing that other courts have made decisions different than theirs, so this is key here. We are cognizant that some courts, including the district court in this case, have concluded that statutes prescribing disturbances of meetings are overly broad and must be accorded a narrowing construction to survive constitutional scrutiny. And they're looking at the Moorhead case, construing statute to criminalize only physical acts or verbal utterances that substantially impair the ordinary conduct of lawful meetings and therefore curtail the exercise of others' First Amendment rights. Given our interpretation of the statute, we do not believe that narrowing construction is required. In this regard, we note that even if there are marginal applications in which a statute would infringe on First Amendment values, facial invalidation is inappropriate if the remainder of the statute covers a whole range of easily identifiable and constitutionally prescribed conduct. Parker versus Levy, a U.S. Supreme Court decision from 1974. Also Smith versus Corona.
And we're probably not gonna get to the end of this, even in this filming.
We might be able to. Rejecting argument that statute must be given narrowing construction to apply only to actual material or more than de minimis, minimal, disruptions. For similar reasons, we reject Hensel's assertion that Minnesota Statute Section 609.72, Subdivision 1, Paragraph 2 must be narrowly construed to reach only fighting words. In this respect, Hensel relies on SLJ, in which the Minnesota Supreme Court addressed an overbreadth challenge to a provision of the disorderly conduct statute that criminalized engaging in offensive, obscene, or abusive language. The court reasoned that the statutory language clearly contemplates punishment for speech that is protected under the First and 14th Amendments, but construed the statute narrowly to prescribe only fighting words in order to uphold its constitutionality. In a subsequent case, in re-welfare of TLS, this court held that the narrowing construction of SLJ does not apply to the conduct-based prescriptions in Minnesota Statute Section 609.72, Subdivision 1, Paragraph 3, Minnesota Court of Appeals decision from 2006. Likewise here, because Minnesota Statute Section 609.72, Subdivision 1, Paragraph 2 is addressed to conduct including speech that disturbs lawful meetings, we conclude that the narrowing construction of SLJ is not required. See O'Brien. That's a famous Supreme Court case too, stating that when speech and non-speech elements are combined in the same course of conduct, a sufficiently important governmental interest in regulating the non-speech element can justify incidental limitations on First Amendment freedoms. Linares, from the Connecticut Supreme Court, distinguishing cases applying fighting words, narrowing construction to breach of peace statutes because they involve statutes that were not narrowly tailored to the nature of a particular site or the needs of specific government institutions. Because we conclude that Minnesota Statute Section 609.72, Subdivision 1-2 is neither void for vagueness nor unconstitutionally overbroad, we reject Hensel's challenge to the constitutionality of the statute. Number 2, Hensel next challenges the district court's denial of her request for 2 jury instructions. A district court has considerable latitude in the selection of language for jury instructions. State v. Gatson, Minnesota Supreme Court decision from 2011. The refusal to give a requested jury instruction lies within the discretion of the district court, and no error results if no abuse of discretion is shown. State v. Mitchell, a Minnesota Supreme Court case from 1998. A district court does not abuse its discretion by using a pattern jury instruction when that instruction accurately states the law. State v. Goodloe, Minnesota Supreme Court case from 2006. Pattern jury instruction basically is, something you can get from a book. I've seen them before. In this case, the district court used a pattern instructions for disorderly conduct charge. See 10 Minnesota Practice, Criminal Jury Instructions, 13-120, 13-121, 2015. Those pattern instructions allow courts to select a subdivision or subdivisions of Section 609.72 at issue. Under the language for Subdivision 1-3, the pattern instructions include additional bracketed language instructing the jury consistent with SLJ that if the defendant's conduct consisted only of offensive, obscene, or abusive language, you must also find that the words used were fighting words in defining that term. And we conclude that the pattern instructions accurately state the law. Hensel requested 2 additional instructions. The first defined expressive conduct and stated that if Hensel's conduct consisted solely of offensive, obscene, or abusive language or expressive conduct, the jury must also find that the words or expressive conduct constituted fighting words. The second stated that only if the defendant's First Amendment protected expression, whether it consisted of words or conduct, is separable from the conduct which disturbed the assembly or meeting, can the defendant be found guilty of disorderly conduct under Minnesota Statute Section 609.72, Subdivision 1-2. The district court did not err by denying Hensel's request for these instructions because they do not accurately state the law. As we noted above, the narrowing construction of SLJ does not apply to the conduct-based prescriptions in the disorderly conduct statute, CTLS. Moreover, the United States Supreme Court has made clear that when speech and non-speech elements are combined in the same course of conduct, a sufficiently important governmental interest in regulating the non-speech element can justify incidental limitations of First Amendment freedoms. The O'Brien case, there is no requirement that conduct be inseparable from speech before it may be constitutionally prescribed. Again, they're citing the O'Brien case. Although the disorderly conduct statute prohibits only fighting words as applied to speech content, the disorderly shouting of otherwise protected speech or engaging in other boisterous or noisy conduct may still trigger punishment without offending the First Amendment. Accordingly, we reject Hensel's assertion that the district court erred by denying her requested jury instructions. Now, they note at the bottom that you mentioned the Sharkey case, and real briefly, Mr. Sharkey attended a city council meeting
In Shoreview,
in Shoreview,
Minnesota.
and he was really upset about something the city council had done. He went right up to the dais, and he was just yelling and screaming.
He was at the podium, and
Yeah,
the mayor
podium.
wouldn't hear him. The mayor refused to hear him.
Yeah.
And she ordered him removed. He clung to the podium.
That's right.
They had to pry his fingers loose
That's
from
right.
the podium to remove him.
And the trial court, the jury there, convicted him of disorderly conduct. He was charged with that. But this court overturned that
Overturned it.
conviction. But this court totally ignores the Sharkey case, and I was surprised. Now, the court is right. Legally speaking, since the Sharkey case was never published, it's not what they call binding precedent. Binding precedent meaning a decision, a prior court decision that they have to follow. Because it's unpublished, it's only persuasive precedent, meaning they can or cannot follow it. But I still think it's very persuasive. I mean, again, what Mr. Sharkey did was way more confrontational, way more disruptive than what you did. And had the court looked at that...
Well,
I
he
think they-
hollered at them.
Yeah.
He said, "You're going to have to remove me. He'll have to have the police escort me out. I'm not leaving."
Yeah, so
Or
had
something
they,
like that.
Had they looked at that, I think they would have ruled in your favor. I really do. But they totally ignored the Sharkey case. And I think that was a big mistake on their part. Even if it is only persuasive precedent, still persuasive precedent plays a role. And now we get to number 3. Lastly, Hensel argues that the evidence was insufficient to support her conviction. And considering a claim of insufficient evidence, this court's review is limited to a careful analysis of the record to determine whether the evidence, when viewed in the light most favorable to the conviction, was sufficient to allow the jurors to reach the verdict that they did. State v. Webb, Minnesota Supreme Court case from 1989. We will not disturb the verdict if the jury, acting with due regard for the presumption of innocence and the requirement of proof beyond a reasonable doubt, could reasonably conclude the defendant was guilty of the charged offense. Bernhardt v. State, Minnesota Supreme Court, 2004. To find Hensel guilty of disorderly conduct for disturbing a meeting, the jury was required to find that 1, she disturbed a meeting that was not unlawful in its character, and 2, she knew or had reasonable grounds to know that her conduct would or would tend to alarm, anger, or disturb others or provoke an assault or breach of the peace, citing Minnesota statute, section 609.72, subdivision 1, paragraph 2. The intent element of a crime, because it involves a state of mind, is generally proved circumstantially. State v. Davis, Minnesota Court of Appeals case from 2003. When a conviction is based on circumstantial evidence, we use a 2-step process to assess the sufficiency of the evidence to sustain the conviction. State v. Silvernail, Minnesota Supreme Court case from 2013. First, we identify the circumstances, prove that is the evidence supporting the jury's guilty verdict. Second, we determine whether the circumstances proved are consistent with guilt and inconsistent with any rational hypothesis except that of guilt, given no deference to the jury's choice among reasonable inferences. And they cite this Silvernail case that they've referred to previously. To successfully challenge a conviction based upon circumstantial evidence, a defendant must point to evidence in the record that is consistent with a rational theory other than guilt. State v. Taylor, Minnesota Supreme Court, 2002. The evidence presented in this case that Hensel moved her chair forward and refused repeated requests to return it to the public viewing area, all the while arguing with council members, although not overwhelming. And again, I must emphasize this. They say not overwhelming. They could have easily ruled in your favor. Is sufficient to support Hensel's conviction. The jury could have reasonably found that Hensel's conduct prevented the council from conducting its meeting, and that she either knew or had reasonable grounds to know that her conduct would disturb the meeting. The evidence that Hensel points to in support of her sufficiency challenge is not consistent with the rational theory other than guilt. Accordingly, we do not disturb the jury's verdict. In other words, they think you intentionally want to disturb the meeting. And here's their decision. Because Minnesota Statute Section 609.72, Subdivision 1-2, Paragraph 2 is not unconstitutionally vague or overbroad, the district court did not err by denying Hensel's requested jury instructions, and the evidence supports Hensel's conviction. We affirm. Now, they were mentioning earlier in one of their analysis, there are other state Supreme Courts that have narrowed their disorderly conduct statutes quite a bit to protect more free speech. And basically, they just say, you know what, we're not going to follow those. I'm just trying to find where that particular section is, but I remember reading that, and it's like, wow, so they know that there are other cases out there,
Well, and-
from other courts.
If you listen to the first segment of our interview together where we talk about my petition to the Supreme Court, my criminal attorney states clearly that the second prong of the disorderly conduct doesn't match up. It's inconsistent with the third prong. That's one big problem, but also, not only is it not very tailored, it isn't tailored at all.
No.
Or something to that
And
effect.
indeed, this court even cites, in their own opinion, other cases from other courts, Linares from Connecticut, State versus Fielding from Georgia, State versus Markowitz from Texas, all of which, in those cases, those courts narrowed their disorderly conduct statute. They said that these statutes are too broadly interpreted. We want to be sure that people know what conduct is allowed and what's not allowed. And yet this court decided, we don't necessarily need to do that here.
And so in those decisions, Doug, do you know if they listed the conduct that might be, how did they narrow it? What did they do? Did they?
Well, I don't know if they listed the conduct, but
They narrowed the speech content, or what?
well, what they did basically was they wanted to give people more protection to, speak out at their city council meetings or other government meetings, and to limit what, could be defined as disruptive, meaning basically you had to use fighting words. You had to intend to disrupt the meeting. It couldn't be just because, you
Oh, so
Yes.
they probably took away the part that says just disturbing the meeting was, that-
right, they wanted to, it had to be more.
Yeah,
That-
you had
because
to use the
disturbing
fighting
meeting,
words.
yeah, could be holding up a sign, it could be turning your back on a
Right.
speaker, it could be, hissing them a little bit, holding up a big banner. I mean, that could all be considered disturbing a meeting, and these courts want to protect that freedom of speech. And the Minnesota Court of Appeals knows about these decisions, but, and this is a prerogative, state courts don't always agree with each other. They decided that, no, we're not gonna do this. We'll let the statute continue as it is, which, as we've said, is just way too broad.
Some little bit of irony here is that Michelle Larkin was the presiding judge on the Shoreview Sharkey
The
case.
Sharkey case, yes. I was surprised, quite frankly, when this decision came out, Robin. I thought they would rule in your favor. I thought they would compare your conduct to Mr. Sharkey's and just say that there's no way that if they could overturn Mr. Sharkey's conviction, which they did, that they could uphold your conviction. I was shocked.
Well, and at the appeal, I listened closely, and I believe it was Judge Workin that I think a number of times stated, couldn't the city, she was arguing with Medillo, who was Paul Reavers for the League of Minnesota Cities helper. She was arguing with him and saying, shouldn't have, I believe she stated first, couldn't the city of Little Falls have had a seating policy? If they, and she was arguing that back and forth. So I was hopeful too that they would overturn the decision, but onward we go to the Supreme Court, and it will,
Yeah,
I don't know what the next step is after presenting this. I don't know if we get a chance to go and talk to the Supreme Court before they make a decision, or if they just can reject or say yes to this. I haven't talked to my attorney about it, so I don't know.
That's something you will want to discuss with him, because I'm not really familiar with their procedures either and what they do. But I really am hoping that they take this case because, it really does implicate First Amendment freedoms. This doesn't just apply to you. This applies to anyone who
Right.
may go into a city council meeting. I mean, for example, Pat Scott, who's a member of the Brainerd Area Coalition for Peace and active with the Unitarians in Brainerd and Pine River, she's wanted to go to the city council and talk about, changing the name of Columbus Day to Indigenous Peoples Day. Now, let's say she felt she wasn't getting anywhere with the city council, and really, they tried a few years ago and the city council didn't approve their decision. What if she brought a sign to that meeting saying, change the name? What if there were some city council members that that sign was disruptive?
That's
Could Pat be
disturbing the
Yeah,
meeting.
that's disturbing the meeting. They told Pat to take the sign down. She refuses. We're just doing a hypothetical here. And she could be arrested. I'm not saying that would necessarily happen, but this leaves that possibility open. Or Larry, you mentioned a good example. Larry singing a song. Could that be considered disruptive?
Or if somebody wore a T-shirt that had a sign on it,
Mm-hmm.
a message of some sort that they felt objectionable, or a hat, even a baseball cap that
Sure.
had something objectionable, that said Black Lives Matter on it, or KKK, or whatever,
Yeah,
anything.
Could be any
you know?
number of things. No,
Yeah, I mean-
so I'm really hoping that the state Supreme Court protects what you did and protects other symbolic speech and really narrows, the construction of the statute to only apply to that conduct which is intentionally trying to disrupt the meeting, trying to shut it down, so that people can go to their city council meetings, feel free to speak out, feel free to protest, as long as they're not trying to, shut the meeting down, and, so the city council can still hold their meeting.
Well, in Minnesota, there's going to be some hot council meetings in every city coming up real soon here, and that's because of the water issues. Lake Pepin at the bottom of the Mississippi River, where it widens out, it's not actually a lake, but it widens out there, is dying, folks. We have too much sediments and nitrates that are going into the waters, creating these enormous algae blooms that are causing our rivers to die off. And the Mississippi is in impaired water. And if you look at the map, I watched this gal whose name was Hasser Camp. No, oh God, it's an odd last name. Anyway, she spoke, and I watched that whole series. It was held down in the city somewhere about the impairment of our waters, and she showed a map of the contaminated wells in Minnesota. And they were in red hotspots. You wouldn't believe how that whole area of contaminated wells, with nitrate specifically, encompasses and goes all around Camp Ripley.
Wow.
And I don't think that that's coincidental. I have said for a long time, it isn't just the nitrates from the farmers. It isn't just the sediments from farm erosion going into the streams. It isn't just phosphorus. In every bomb, in every missile, even these explosives that are fake, like fireworks kind of thing, to give the image to the troops to train them, all of that stuff has enormous toxins in. And where does that go? In the air, in the ground, and in the soil. If you go on Google Map or Google Earth and you look at our Camp Ripley bombing ranges, there's 4 of them out there, you can see where the earth is actually split. There are open crevices from the bombing.
Wow.
And that stuff has to be going somewhere. I don't think it's any coincidence that the city of Randall has 2, not 1, but 2 contaminated wells. And I read recently in one of their city council meetings that a potential well that they drilled now has way too much manganese in it. Guess what? Manganese and all that stuff that they're listing, that they're finding in all these wells, it's coming from out there, folks. You better wake up, get your eyes open. And even if that wasn't true, we have a problem in Minnesota. 45%, it's either 40 or 45% of our water, all of our water, is contaminated. That's a huge issue. And it's going to come down to, there's a proposal to tap, I want to say it's Lake Erie's water, to go to one of the big cities. And there's going to be more. There's a pact to prevent that from happening. But you talk about hot city councils. When and if the residents' water price, the amount that they have to pay to get their water from the groundwater, doubles or triples or increases substantially, we're going to have, that whole council is going to be full. In fact, they're going to have to seat them in that area where I was seated because there won't be room. What are they going to tell them? You can't come in here, you have to go on the hallway? No, they would put additional chairs in the same area that I sat in.
And see, the thing is, not everyone who would attend that council meeting is necessarily going to be polite and,
Oh,
observe the
they're going to
proper
be mad.
decorum.
They'll be mad as heck.
And so, should someone, because he or she raises his or her voice or holds a protest sign,
Or refuses to stop when their public forum
Right.
comment time is done.
3 minutes, and they go over, could they be, arrested? And unfortunately, the current state of Minnesota law says, yeah, it's possible.
Right.
That needs to be changed. That really does. You
Right,
know.
it's real important. So, thank you for watching this episode. We'll keep you posted as to what the next steps are. The minute that I can talk about the next step, whatever that is in the process, I'll be happy to have Doug come again and we'll discuss that so that you can have the first news, and nobody until this film, you know, I haven't discussed this with anybody. I just got permission from my attorney to talk about this publicly a couple days ago. So I wanted to put it first on here, and it'll also be on my blog so that you can see our talk on my blog as well. And that's robinhensel@blogspot.com. Thank you so much for watching, and stay tuned, and thanks for coming, Doug.
Absolutely. I'm so happy to be here, Robin.
Good afternoon.